Good afternoon, everyone. Good afternoon to all our distinguished facilitators and all our professional colleagues. I welcome us all to the day 5 of our civil litigation training 24. Um, let me apologize. We're supposed to have Chief Panu Agabi take. Unfortunately, is unavoidable. I think he had some emergency. I spoke with him earlier. Is no less distinguished. We have Mrs. Nella and Rabana, Mrs. Nella and Ewa Rabana with us. My colleague will give a fuller um, profile of her, or a fuller profile before we go into today's session. As usual, we have a Q&A box, so all our colleagues who want to ask questions, please type in your questions in the Q&A box so that after the presentation, you can, because as as said in the Q&A box. Now, Mrs. Funke Adekoya ICN for joining us. She's one of our distinguished facilitators. Her session is I believe is tomorrow. We're looking very much looking participated in that session. Thank you very much for joining us. I will, without further ado, I'll over to my colleague, Mrs. Mabel Okereke, as speaker today, manage the process going forward. Thank you very much. Mabel, I think we have just a second. I think we're having
Yeah.
we're having some connection problems, but we'll start in 2 minutes. I'm sorry about this. It's just we're sorting them out, so we'll be back online in 2 minutes. I'm so sorry about this.
Good afternoon, distinguished senior advocates and members of our colleagues that are here today. I have the pleasure of introducing our participant for today. She's Mrs. Nella Enyiwa and Iwa, senior advocate of Nigeria. She has acquired over 38 years of experience working at the very top of the legal profession in a variety of capacities, both in the public and the public sector. Her career has afforded her the opportunity to represent both federal government of Nigeria and state governments. She's also been involved in international negotiations. As the Attorney General of the Cross River State from 1999 to 2023, from 1999 to 2003, she assisted the government of Cross River State to create an efficient legal framework for the development of its agriculture, education, health, infrastructure, environment, transport, energy, tourism, good governance initiatives, and crossing across institutional sectors. During her tenure, she became the first African female to address the International Court of Justice as counsel. She has strong relationships and practice area that has spanned across different jurisdictions and has played in private sector in different international organizations. She was elevated to the rank of Senior Advocate of Nigeria. She's a life member of the Body of Benchers. She's a fellow of the Institute of Chartered Arbitrators. And then she was appointed as a member of the 5th Governing Council of the Human Rights Commission and chairmanship of the Leprosy Mission of Nigeria. Indeed, her practice has been quite versatile. She's a principal partner of Lex Global Partners Limited, a renowned legal practice and consultancy services firm in Calabar and in Abuja as well. She has applied relevant experience to strengthen her partnership, and she was also appointed member of the legal committee of the National Council of Privatization. She's been a member since 2017. She's been involved in diverse public interest matters, human rights litigations, especially in matters of exclusion, abuse, and discrimination. She is positioned to provide qualitative and initiative practical solutions. Her profile is indeed impressive. I would crave your indulgence, Leonard Silk, to keep it brief. But without much ado, please join me. Welcome distinguished Leonard Silk as she presents her paper. Thank you very much.
Thank you. Thank you very much. Mrs. O, let me start by recognizing the distinguished members of the faculty of the NBA, Institute of Continuing Legal Education, the chairman, NBA ICLE, Mr. Tobina Erojikwe, and the coordinator, my Leonard brother, Silk, Tola Oshobi, SAN, and all participants, resource persons, my colleagues, other senior advocates that I have not specifically mentioned, and my other colleagues, let me say good afternoon. Let me particularly thank the organizers for giving me the opportunity to share my thoughts on a topic which I find quite central to any desire of the lawyers, of any lawyer. I want to believe that when you are called to bar, the singular thing is that you want to make your profession a success. Now, my topic is preparation for trial. And please, next slide. I have, as you can imagine, that's the whole gamut of civil litigation to be crunched into an hour. So what I have done is basically, apart from the intro, to divide it into 3 broad segments: preparing for trial, steps incidental to trial, evidence, then close of evidence, recommendations, and conclusion. Next slide, please. Next slide, please. Next, yes. No, just take me back. No, the next, because I made a comment. Can you go back? Yes. Abraham Lincoln said, go back. No, you were right before. Can you just move one step forward, please? Hello, are you there? Are you there?
Yes, I can hear you. Yes, we're moving. Yeah.
Okay, just one. No. After contents, you have protocols and a picture, which I just saw actually. So yes. Abraham Lincoln said, give me 6 hours to chop down a tree, and I will spend the first 4 sharpening the axe. I thought this captures everything that I'm going to be talking about, because without preparation, you're not going to make any real impact. Without preparation, you're prone to mistakes. Without preparation, your ability to understand the particular subject matter is reduced, because your investigation and research would either be absent or be misplaced, because you don't have enough time to digest the issues. Now, so I thought to just draw attention, because I think that this quote is the reason why we're here. And I want to thank the organizers, because you might think, oh, these are topics, all these topics, all the lawyers know it already. True. But the motivation behind ensuring that you keep these steps, or you follow these steps, is the purpose for which I am speaking today. Next slide, please. Next slide, please. The key to effective litigation, and in particular efficient trials, is preparation. Rules of professional conduct require every lawyer to provide competent representation to all his clients. Competent representation requires sound legal knowledge, skills, and preparation. Proper preparation or attention to details of the matter, both to law and facts, are not just critical, but are mandatory and essential. Therefore, failure to adequately prepare, thereby putting the client's interest in jeopardy, could lead to disciplinary action. Next slide, please. From the 4 modes of commencement of actions, namely writ of summons, originating motions and petitions, or by any other method. Actually, the slide is not helping.
We're sorry. I think we're having some challenges. Let it still. I think you should. We will sort it out. But I think you should just go ahead, please.
I will.
But I think we're on the slide you want now, I believe.
Yes, you are.
Okay, but we'll sort out the back end issues. I'm so sorry about this.
No, that's all right. Basically, for our purposes, I'm going to focus on writ of summons, because that would better illustrate the stages in a trial, and also show what ordinarily is expected of one. Now, the question is, what is a trial? A trial is a proceeding of a court or tribunal, including all judicial or quasi-judicial bodies, in which evidence and arguments are presented and evaluated so as to determine the guilt or innocence of a person standing criminal trial, or to resolve a dispute in a civil matter. I did put, and I think when you eventually get there, the preparation for trial. Preparation for trial is the trial plan, the order of witnesses, and witness briefing. Now, the quality of a lawyer's presentation is largely determined by his trial plan. An effective and efficient trial plan is a product of inquiry and analysis of the factual and legal elements of the matter. A trial plan helps the lawyer develop a general strategy. As a matter of fact, the moment you begin to plan, you find that it's just a natural progression that you begin to think of the strategies to implement and deal and achieve the outcome that you desire. And that's why I said at the beginning that planning is so important, because for you to succeed and for you to appear to be the genius that you are, you really have to sit down, figure it out. How do I approach this matter? What are the strategies I need? What should I be investigating? What should I be looking at? What is important and what is not? What have we agreed on? What would be the template in this case? Because every case is unique. Who are the kinds of people I should use as witnesses? If there are certain witnesses you call that are not credible, there are certain witnesses that you call, and in fact, they might just cause the judge and even the others to wonder what is going on. So, but you don't just jump into those decisions without first planning. And that's when you prepare, like I said before, you investigate, and then you distill what the case theory would be. It is that plan that will produce a blueprint for implementing the case. Please, next slide, because I have to move quickly. Now, I have in the slide, so as to save time, the order of witnesses. The relevant section is section 215, Evidence Act 2011, where, of course, it either, when you're opening your own witness, it gives examination in chief, and the purpose would be to elicit not the whole document because you adopt it, but just to show and highlight those areas, especially where you want to tender documents which you probably had not which you intend to tender and which are central, so that you don't have any problems. And I'm talking about in civil matters. The prosecution goes first, of course, in criminal, and the strategy may affect the selection and order in which witnesses are called. Sometimes you feel that, okay, this is your star witness, you want him to come last. In some cases, you want him to come first. And some cases, you slot him in the middle. But this is not something you just wake up and decide. It's something you would have prepared for. Now, witness briefing, of course, is very critical. And it's critical because you really want to demystify the process of adducing evidence in court. A lot of witnesses, as smart as they are, panic. When they see the lawyers and their stern faces, they even forget everything. It's not that the facts are, I don't think the idea is for you to coach them, but it's for you to remind them and for you to assure them that it's okay. Just say what it is. It's okay. Don't be rude and don't be agitated. Those are the things that make witness briefing very important. Now, the second stage, the second thing was steps incidental to trial. I think you could move the slide a little bit. Thank you, but I'll continue. Under incidental to trial, we have the ruling, you have hearing, you have response time, you have service, and you have application. Let's go to the next slide. What are the notes there? I think I wouldn't dwell on this because this is standard. Any matter you do, what I would say at this point, when you prepare properly, that means you're going to look at the relevant laws that apply. And if you're in Lagos, it will be Lagos State. If you're in Calabar, FCT, Federal High Court, and the days you have to check. So you have to have the High Court rules and you have to check. And at this point, I will also say that preparation includes you doing a research to know what the relevant statutes in respect of the particular case, if it is banking, if it is intellectual property, and all that, you need to establish what forum. There are different, the extent or the need to comply with the Evidence Act is pretty much standard. They may overlook, like, of course, for those who do electoral cases, you find out that they may be, because it's sui generis, they may be a little bit, I wouldn't say lenient, but they may not be, they may allow you some laxity. But having said that, if you want to practice and if you are preparing properly, there's no question about it. You must have the provisions of the Evidence Act at your fingertips. And I did talk about admissibility, relevance, laying foundation, computer-generated evidence, competence, and compellability, affidavits, under which you have subpoenas, defective affidavits, conflict, and close of evidence. These must be at your fingertips. And you see, the relevance of this and preparation is that you can anticipate what is going to come next. When you begin to segment your facts, you begin to segment the law, you find out, am I going to be able to tender this document without stress? And if I do not, if there's going to be a challenge, what are the challenges? And you prepare. So it's not that of course, if it's an original document, you don't have a problem. The problem usually is if it's a secondary document. Something got stolen, something got burnt, or it is in the custody of a person who is refusing to release it. You need to have prepared before you come, because they could just keep quiet. And as you try to tender, they hit you. What do you do? Would you now be looking, they say, okay, address me on this. What do you say? Then, so I now have evidence, legally admissible materials used by lawyers to establish the existence or non-existence of factual situations. The reason I actually, so you don't panic, the reason I actually put in all this, so that if you get the document, you can read it. But I'm going to skip and jump some of these issues, but they are well documented in the slides. Now, applications that may be brought during trial is very important. A lot of the time you find, if you had only taken a little bit more pains, if you had prepared, you would see whether there are threshold issues to be argued. You might even file a preliminary objection based on abuse or jurisdictional issues, those kinds of arguments. And it will spare everybody their time, because the court also usually has the power to suo motu decide on certain issues. Now, the applications that may be brought during trial could be preservative, on notice or ex parte, applications for summary trial, which is undefended list, which is always on notice, substituted service, could be ex parte, usually it's ex parte actually, and amendments. Please, the next slide, I think, let me go to admissibility and relevance. I've spoken to this. Now, this is important because that's where a lot of your advocacy goes up in flames. Doesn't matter how knowledgeable, doesn't matter how eloquent you are. If the crux of your matter is resting on a particular document and you don't pay attention, everything will go up in flames because it will be inadmissible, period. There's nothing you can do about it unless you prepare. So I'm back to preparation. Unless you prepare, when you prepare, you will notice that this document is not original. You would ask yourself, do I go ahead and lay a foundation? Would it be sufficient? Or do I, if I don't have a certified true copy, what should I do? And what are the relevant sections? Because even if you want to file a motion, you have to know which of the sections apply. Now, I will take this opportunity, here, because we had the graphic design that covered evidence. And one of them is this issue of tendering an electronic gadget or information from that. It looks as if it is superfluous, but it is not. You have to always know when to apply in your writ of summons and in your statement, wherever, that section, what section the 84 of the Evidence Act is saying. A lot of the time, you bring in documents, you bring in foreign ones, and these are all specific, there are specific provisions for you to tender them, first refer to them, tender them, and you will be able to tender them ultimately because you have made you have conformed or complied with the prescription as contained in the Evidence Act. So, for instance, Section 84, Section 87, you just have to know at your fingertips. Please, can we move? Relevance is the bedrock of admissibility. If it is not relevant, it has nothing to do, and you bring it. So even in your language, when you prepare sufficiently, it will always come up. And so the language you use, the way you introduce it, the way your what you might call them, your witnesses on oath, the way they lay, the way they introduce the points they're making, and it would become deliberate and intentional. This is what stands you out from most others. Of course, you have Section 1, which I will jump. Now, laying the foundation, I think, is what I've been talking about all this while. Can we move, please? Can we? Yes. Laying the foundation applies to situations where evidence sought to be tendered is not in its original form. Like I said before, for private documents, you can tender photocopies or give oral description as to the document after laying the foundation. For instance, as I said before, has it been destroyed? Is it in the custody of the adverse party? Is the original missing and all effort to trace it has proven abortive? Has it been stolen? And you have a police report, because a lot of people will even say that it has been stolen, but there's no police report. And so it goes out of the window. Now, for public documents, if it is not original, no amount of foundation can excuse the failure to produce a certified copy. Next slide, please. Next slide, please. Thank you. competence and compatibility is another critical element. Why we took time to do this, because there's so much more, but it's because these are the ones that come up. They're so fundamental. And when you gloss over the work, when you do not prepare, when you don't do your legal research, when you don't ask questions, because even in cross-examination, if by chance somebody asks the question, when you have that understanding, then they would not knock out a witness simply because of the way and manner in which he was brought. Of course, competence is clear. If it's a minor, it's not nothing. That's not going to happen. Now, the relevant sections, and by the way, I put this knowing that most of everybody here knows all of what I'm talking about, but it's just to remind you in how you prepare. So you don't come to court and wait when it's raised, when there's an objection raised, you attack. Meanwhile, if you had done the research, you would have had the answers, you would have had the sections, you would be armed, and you would defend your position and your choice. Compellability, not all competent witnesses can be compelled, i.e. diplomatic immunity, and of course you have me too. Can we, the commander-in-chief, can you go to the next slide, please? How many minutes do I have left? So I can, please, are you there? How many minutes do I have left?
Yes, you're meant to stop at 4 so that you can take the Q&A by 4.
Okay, good thing I asked. Okay, that subpoena on top is an error. It was that we were meant to have just affidavits. Now, this type of subpoena is a writ issued by the court. That is subpoena ad testificandum to a prospective witness requiring the desired witness to attend court and testify. So your research, your preparation is that you choose based on your informed, it becomes an informed choice when you have done your legal research and you know what you want to achieve, which is your strategy. And that's what the theory book I was talking about. And you know that, okay, if I bring this witness, it will be a subpoena ad testificandum. If I bring this one because he's in jail, it has to be subpoena habeas corpus ad testificandum. If it's subpoena deus tecum, then of course, that would be the fact that you just want him to come attend court and is also summoning the witness who is required to attend court to testify. So there are some you don't need them to testify. All you want them is to be in court and tender. Some you want them to testify apart as well. So if you don't pay attention and say they are all subpoena, and you go ahead and issue the wrong one, you're stuck. Next slide, please. Next slide. Close of evidence and trial, of course. Close of evidence and trial. Trial is said to be technically concluded where the last party to lead evidence closes his case. Sometimes when it's over protracted, either the opponent, the other party might request apply, or the court may use its discretion. But once both parties have closed their cases, that's the close of evidence, and incidentally, it's also the close of the trial. They would have filed their addresses within the time given. By the next adjourned date, when the court sits and they adopt their briefs, or in some cases speak to it, that marks the end or the close of evidence and trial. Let me go to recommendations. recommendations, please. Recommendations, please. Right. From all that I have said, because as I said, it's not possible to cover the field, but I think I'm hoping that by virtue of the scenario of a tree and the axe, which shows how important it is for you to prepare. That means you would have identified the relevant and applicable laws from the outset. You would distill all relevant facts in issue and align them with arguments from applicable laws. You will filter the evidence while evolving a case theory. You will consider the threshold issues way in advance. And if need be, you file the objections and motions, as the case may be. You will take pains to prepare your witnesses. I didn't say coach your witnesses. I didn't say putting the words into the mouth of the witnesses, but remind them. Sometimes, well, it's just what it is. By the time they come, they've even forgotten what had happened. So you refresh their memory. You let them see why, whether, you listen to them, because some of them don't sound credible. And as a matter of fact, you ridicule yourself when they speak. So you may decide, you know what, let this witness not come. Some of them look aggressive. Some of them, their demeanor or there's no lack of decorum could jeopardize the interest of your client. And therefore, the ones you think would rather be unhelpful, you may decide, because you're at liberty, not to call a witness that you had written down, because it will just be taken as abandoned, period. Then you exhibit good advocacy and persuasive communication skills. Communication skills, I cannot emphasize. Language, I cannot emphasize. Ability to convey your thoughts, I cannot emphasize. Facts gathered will be forgotten if not recorded. I've noticed in recent times that people are not too keen on writing down what they think as little things. But those little things, when you need them most, you forget. When you need them most in context, you lose the essence of the context that made it relevant to what you're doing. So it's always suggested that if you have a record book, go ahead and put what you believe, compile like a trial note, which would ultimately produce a preparation checklist. One of the things I've noticed, we tend, like even a restaurant, you go to a restaurant and all of you are talking and they don't think they should write it down. And they say it's in my head. Now that can't be good. As a lawyer, you have a checklist. Have I done this? Just before have I done this? Have I prepared? What is the section? If they say this, what do I do? This is what makes you stand out. This is what makes you ready. This is what makes you competently defend your client or present the case of your client. In conclusion, I say, have a checklist on things to do in preparation for the trial. If all the boxes are checked and ticked, then you are good to go. Even you come in with the kind of confidence that is unimaginable, even when ordinarily you should be worried. Always remember, cases are not won or lost by being just in the courtroom. The foundation for the courtroom outcomes is the trial preparation, which is done and made before you ultimately find yourself in court. Next slide. Thank you. Thank you very much. And thank you for listening.
Thank you very much, Leonard Silk. I do apologize for the problem with the technical problems with the slide. I think our internet speed was a bit slow, and I know that affected the presentation. I do sincerely and profusely apologize. And again, but I think the presentation was very good, and we're very thankful for the presentation. I also know that we had to move you forward because of the incident with Agapi. And obviously you had to rearrange your schedule at short notice. But that said, we are very, very grateful. The slides are excellent. We would share them. Thank you very much, Leonard Silk. Thank you very, very much. We truly, truly, truly appreciate the presentation, and we apologize for the technical issues. Please forgive us. So I'll just hand over.
I think in politics, they say
Go ahead.
Glitches. These days we use I said these days we like to use the word glitch. You know, for everything we use. So it's fine. It's okay. Thank you.
Oh, thank you so much. So I'll hand over to my colleague, Mr. Okereke, to handle the Q&A session. Thank you very much.
Thank you to you, and thank you, Leonard Silk. I'll just jump right into the first question here. This is from Tijani, and he says, is it imperative to cross-examine a witness immediately after examination in chief?
Well, because you use the word imperative, it's not imperative. In fact, I think some lawyers would rather adjourn and come back. So it's not imperative. But for you, the practitioner, I would think that you would look. You see, there are some witnesses that you know they are flawed already. When I find myself in such a situation, I do not allow them go. I make sure that, it's better, without sounding morbid, you just kill the matter right there and then. Because when he goes back, there's every likelihood that he will be shown, or he would be, I don't want to use the word coached, but he will be guided on how to reduce or minimize the damage that may have been caused. But in plain answer to your question, it's not imperative. There is no law that says you must, which is why people adjourn for the next hearing. But let me also say that I notice also that a lot of judges don't like that. What I mean, they want to dispose of these cases on time. So they may urge to go ahead and cross-examine. So if I were on the other side, when you go to court, don't think that, or don't expect that because the other side have just closed their case, that you would have the opportunity of coming back the next adjourned date to cross-examine, because that means you're lengthening the time, and that may not be desirable. Thank you.
Thank you, Leonard Silk. The second question is from Kenneth Chukwu, and he says, please, what is the law on photocopy of the certified true copy? Is it admissible in law? Is Minister of Lands, Western Nigeria and Azikwe still good law on photocopy of CTC being admissible? Thank you so much, Leonard Silk.
Thank you. The question you asked was whether a photocopy of a CTC. Now, if you know what you're tendering, don't forget on all the annexures you have, there are photocopies. So I don't believe that's the question is asking. If you do not tender in court the CTC, the certified true copy, it will not be admissible. I hope I'm answering his question, because what ordinarily would have happened when you're filing your processes, you have attached to them the photocopy of a certified true copy. But when you're in court, you tender that certified true copy. And where you fail to do that, I don't believe you would get away with that. As per the second part of the question, which is whether the Western Nigeria, and I believe
Azikwe, please. Minister of Lands and Western Nigeria.
Well, well, this has taken me a little bit unawares, but logically speaking, why would you want to bring them unless the matter in issue happened at that time? You may, but you see, is that law still subsisting? You know, or you may wish to I would say exhume it or attempt to exhume it using the Constitution 316 or 315, but I don't think so. As we speak, most of those areas have been covered by laws that are valid and are subsisting, and usually they repeal. The reason why I'm a bit hesitant is because I cannot say for sure it had been repealed. If it hadn't been repealed, by the way, then it will still be valid. But you may need, it won't be straightforward. You would have to lay this issue of laying foundation. You will have to lay the foundation for it to be applicable and admissible. And of course, relevant. As for relevancy, I believe the facts in issue, if it has nothing to do with if the matter that is being disputed is now, for instance, why would you go to Awolowo's time? I don't know. So I think there will be an issue of relevance before we even go to admissibility and laying of foundation. Thank you.
Thank you, Leonard. Ikeria Benny Ebony says, please, can subpoena this TECON be issued also in criminal trials, especially for magistrate courts?
I believe that you can, because what you want is for the witness to tender, what you want is for the witness to come into court, and especially more often than not when it might be a hostile one. I believe the magistrates, depending on, you see, everything also depends on their own rules. It's been a while actually since I've gone to the magistrate court. But having said that, there are clear guides. So the answer I would rather give is, right, maybe if you intend to do this, just check the rules.
Thank you, Leonard.
Check the rules.
Ikenna Eme, will Leonard Till kindly give further expositions on methods for correcting an affidavit?
Oh, it depends on, because there are quite a lot of exceptions where the court, notwithstanding the irregularities, would go ahead and admit those affidavits. Now, if the affidavits conflict, if that is the question he's asking, the court has the power to order for oral evidence, because where they conflict, automatically you cannot and should not decide on conflicting affidavits that he has not been given an opportunity to listen and to ask questions, deeper questions, since the documents cannot speak. So that would be my answer. I wish I could hear to know if that's the question, if that's that's the answer. Rather, this question has been answered. You know what I mean? Because sometimes when you engage in that way, you might think he's asking one thing and you're answering another. So I'm hoping that that answers his question. Yeah.
Thank you. This is from an anonymous attendee. It says, my question is, as counsel to third and fourth defendants in a matter having 9 defendants, What process do I file in response to multiple counterclaims and statements of defense of co-defendants challenging third and fourth defendants?
No,
Not
okay, sorry. Can you
Not exactly on the point
well,
for this afternoon, but you may want to just assist
but
here.
yes, that's why I'm smiling as well. But do you mind asking that particular question again?
So he's counsel to the third and fourth defendants, and there are 9 defendants altogether in the process. And so he's asking, do I file a multiple counterclaim and statements of defense of co-defendants challenging the third and fourth defendants? So my question is, I'm as counsel to the third and fourth defendants, and in a matter having 9 defendants, what process do I file in response to the multiple counterclaim and statements of defense of co-defendants challenging the third and the fourth defendants?
Question is it very
I
clear?
would rather,
it's convoluted.
It's a bit convoluted, but I'm thinking, okay, let me just take, you know, when you float, sort of, when you glide, I would take the posture of gliding, where I think what he's saying is asking. The first point, I hope, is that he's saying, or she's saying, I represent the third and fourth. The presumption here is that the 9 parties have filed, maybe the other parties rather, have filed their
respective
claims.
counterclaims, yes.
Yes, respectively. So you have to respond respectively also. So if what is coming at the 2 that have now raised specific issues, with the third and fourth, who he represents, you answer them specifically, not joint. I think that if you join it, I don't want to use the word lazy, but you are at risk. You know what I mean? You're at risk. Just file a counter to whoever has raised an issue that you must. Otherwise, if you don't, then don't forget, it will be deemed that you admitted, and that's a real risk. So please, just even if it might look as if you're saying the same thing twice, because sometimes people feel that it doesn't matter. This is a counter response to the whoever, the fourth defendant, the sixth, the first, that sort of. So you're specific. Thank you.
Thank you, Leonard Silk. Afolayo Ezekiel says, can you correct an affidavit orally?
Most courts will not even allow you to do that. That's the point. But I don't know why people try to do that. Just go and file a motion and correct whatever you need to correct. Most courts won't even allow you anyway. So, but just in case somebody attempts it, I would rather, because they might keep quiet in the address, they bring it up. And if it's brought up, you never know. So do the right thing and go by way of motion and amend whatever it is you want to amend. It's safer, it's better, it's tidier.
Thank you so much. This is from Aliyu Ibrahim Mohammed. It says, my question is, can original of public document be tendered through person who is not the maker of the document?
The question is, can you tender a document through a person? Why would you tender it through a person who did not make the document? But I think there are circumstances, especially when the issue will be the capacity in which the person tendering it is tendering it. I don't want to say it outrightly that you cannot, but it is not. But it is preferable for you to seek for. And that's why we talked about preparation for 1 hour. Hunt the person down. Use your best, with your best source. Why? Because I'm just wondering, but it's not coming to me immediately. But I think there's some very, very unique circumstances, extenuating circumstances, whereby you can admit. But then again, if you were to do that, because there will be an objection, you have to go and look at the circumstances that are extenuating, and pursuant to that section, you attempt, let me use the word attempt, because it's still the discretion of the court to either accept or not accept, admit or not admit the documents you're seeking.
Thank you, Leonard. And I'll pause at this moment. There are lots of accolades, comments, appreciation from the participants. Emmanuel Agbade says that this is very insightful presentation. Kindly share your slides with us. We tell our participants, as always, that the slides are available and we'll share them with you. So I just wanted the Leonard Silk to know that I can't possibly go over all the feedbacks and the comments we have in the chat box, but there are lots of thank yous to you. This is a question from another anonymous attendee, and he says, where a person wants to appeal a judgment, I know this is not part of what you asked presented today, but was not part of the original suit. Can the person file the evidence that they want to rely on the appeal immediately? Or would they first of all need to seek leave of the appellate court to adduce further evidence?
They must seek leave to be joined, because they were never there. They've not given any evidence. I know it's not impossible, but it's very difficult. But it happens. Because I've had occasion where the people fight and really think about it. Possibly, sometimes it is because they did not know that matter at the time it was pending at the lower court. They were not aware of it. And by the time they got to know, their interests had been adversely affected. And, so I think that would depend on your ability and capacity to convey, which is, again, one of the things I was talking about, which is effective communication. You really have to be deliberate in how you even write an application. Sometimes the application is almost as if you can give, you can grant, or you may not grant. It's not like that. You have to more or less persuade the judge. If it's on appeal, you would file your motion and make sure that it is sufficiently, that you have been able to show sufficient cause why the court should grant in your favor. And it's not impossible, but I know it's difficult. And it's difficult because, you did not participate at the lower court, and so there's nothing to rely on. Thank you.
Thank you, Leonard Silk. This is me echoing Idoko Opanachi. Says, wow, I'm impressed. Despite the glitches, I enjoyed every bit of your presentation, Leonard Silk. And he says, thank you very much. Adetutu Aderemi Iheri says, if as a defendant's counsel, you observe that a party that I'll take that again. If as a defendant's counsel, you observe that a party that you filed a motion for his joinder is refusing to appear in court or file any process because he committed forgery of the documents by which he made representations, can he be subpoenaed or be compelled to come to court?
The only way you can subpoena him because he doesn't want to come. Sorry, the only way you can compel him because he doesn't want to come to court will be to subpoena him. And I think that's what that provision is for. Because while others would rigorously apply and seek to be joined, there are some people, either they're indifferent and they think it's a waste of their time and they have nothing to gain or lose. And some, because they have something to hide, they don't want to come. So those kinds of people, like I think that's what he's saying, should apply either to court. I would have preferred to actually go through, let the court subpoena that person. When is the court subpoenaing you? You will come. Do you know what I mean?
Thank you.
So,
Japheth says, many thanks to you, Leonard Silk, for this enlightening session. My question is, in a civil matter where there are multiple defendants with different counsel, what will be the order of examination for defendant's case and a co-defendant cross-examined after the claimant has cross-examined with different witnesses? Also, can there be different counsel for multiple claimants in a matter?
oh, yes. Let me take the last question first. Of course, even by implication and even by the question somebody asked earlier, you sometimes have different counsel for, in fact, sometimes each of the defendants. So that can happen. The fact that you tend to see that they're clustered, so you might have 3 or 4. I'm appearing for the chiefs, I'm appearing for the government, I'm appearing, so you could have that. But even if they're individual counsel for the respective parties, that is not that's not unusual. But the second question he asked was the order. When it comes to you, the claimant, after the claimant for cross-examination, you start the second, the third. So it's in that chronological order that the other parties, the defendants rather, will cross-examine one after the other. Of course, if it's one lawyer for 3 or for 2, he would cross-examine. But after that, the re-examination goes back to the claimant. I hope again that that's the question he asked and that I've answered.
Thank you very much. Olushina says, thank you, Leonard, for this insightful presentation. Can lawyers record examination in chief and cross-examination? I would imagine he's saying, can they record it electronically? Can lawyers record examination in chief and cross-examination? In the world of technology, you have your device with you. And
yes. And so, since there's, we take our time. Let me answer through, the way I think. I don't think you're going to bring a recorder and put it in the full view of everybody, because it might even constitute a kind of distraction. But having said that, I think for youngsters, for a very long time, a lot of people actually record those things, even though traditionally what we do is that the most junior on the list is actually made, and they learn, incidentally, they learn by just not looking around and not chit-chatting, record verbatim or try to record the proceedings. And then they go back home, make notes, get it typed, and put it in the file. So the question that he asked, whether you can, I don't know that you cannot. That's the truth. I even know that a lot of people do. So unless you want to make an announcement, I think it's your choice. Do you know what I mean? That's what I think.
Thank you. Rosalind says, when witnesses are asked to be out of court and out of hearing, does that apply to claimants or nominal complainants? Would you be called to, who could be called to testify as a witness? Does that apply to claimants or nominal complainants? Who could be called to testify as a witness?
I think
when witnesses are asked to be out of court and out of hearing, does that apply to claimants or nominal complainants? Who will be called to testify as a witness?
Interestingly, the claimants or
the nominal complainants, who would be a witness also in the matter?
Yes. I don't know. I think I'm having a mental freeze now. I'm trying to remember because, you know, everything is dependent on the rules. However, I don't see, I don't know. It's just, I don't see the complainants being asked not to be a part of the proceedings, even when he would take the stand. That's what I don't see at this point. That's for me. I think it's obvious, but it's a bit tricky. I don't want to misinform the audience. So
Thank you.
I would suggest if you just check, just go and check, please.
Thank you. Stephen says, suppose a witness dies before he's being cross-examined. What happens? Let's say there was an adjournment, for instance, after examination in chief. You mentioned the possibility of adjournment before cross-examination. And in that intervening period, that witness dies. Says what happens?
You have to substitute the witness. That happens a lot, especially in those cases where the people are in their 80s, even though now our reality is that people die at any time, so it's not about age. But having said that, if that eventuality, if that happens, the straightforward thing is to apply by way of motion to replace that person. And because you cannot cross-examine that person who just died, they're going to have to call him afresh, and so that you can cross-examine him. So I suppose while you apply, I don't think that will take time. If there are many, they'll just continue, and then this last person will come, the additional witness, which is on the as his own. The reason for that will be death of one and substitution of another. And of course, in some cases, it's just the one witness. Now that, you know, is a difficult reality, but it can happen.
Thank you so much. On the issue of relevance, why do judges admit documents that did not comply with conditions set out by the Evidence Act simply because they are relevant? Should a relevant document not comply with the Evidence Act?
Well, he will have to be more specific on that one. And the reason I say that is because I do not know any judge who will deliberately admit a document that has that is not compliant and not in accordance with the Evidence Act, the principal law. I don't know that would happen. But peradventure, you are minded, then you can appeal singularly on that point, especially if you think that document, because you see, the person objecting may think that it will damage his case, and they've already made a mistake, and then he makes noise, but you know that you're at risk, because if after all that, if you go up to the higher court and come back and continue, and you lose out on that matter on appeal, you already lost ground. I don't know.
Yeah, thank you. Aisha says, is there any provision of the law that prevents a lawyer from deposing to an affidavit?
No, I don't think the issue would be because he's a lawyer. Lawyers depose to affidavits. Yes, but in your own case that you're handling, you cannot be the deponent. You cannot. So that, I think, is the scenario. Do you know what I mean? A lot of these things, you know, are in context.
Thank you. This is another one. The more I try to finish the questions, I have 25 questions. So I'm generally appealing to our participants that we can't take all the questions, but yes, the slides will be available. We have very limited time. And I must thank Leonard Silk. this has been a practical session. You've shared quite a lot of insight on questions from our participants. But I'll try and run through this. This is from Olu Kayode Enito, senior advocate. And he says, file your statements of defense to the claim. File your defense to each counterclaimant in specific paragraphs of the statements of defense and counterclaim. I think this is a comment on an earlier question. Yes, and Mr. Samson Osondu says, please, Leonard Silk, in a situation where two affidavits are in conflict and the court calls for oral evidence, are counsel to both parties at liberty to cross-examine the witnesses based on the oral evidence they gave in open court?
They are at liberty. But you see, that also depends on the direction of the judge himself. If he says all I want is, he just wants to ask them questions, don't forget the likelihood of affidavit evidence will be in originating summons. So ordinarily, it's supposed to suffice. But there again, most of the time, people think it will be faster to go by way of originating summons, only to discover that it's contentious. And I always wonder why you won't just order them to file writ of summons and just go the whole hog of a trial. Because for as long as it's conflicting, there is no way you can decide unless you hear oral evidence. The probability, it could be that the mindset of the judge is, all right, maybe it might be even an isolated issue. So let me hear them out. And he may not, because if he is entertaining a matter as an originating summons, and yet he is allowing cross-examination, then it's like you've gone out of the ambit of originating summons and the rules, and you're now entering into a writ of summons procedure which you did not grant and which you did not order. So I think that should be what it should be.
Thank you, Leonard. One number that says, Mr. Perky, please ask my question. I think I've taken a lot of questions already, and we have exhausted the time. We have 25 more questions. I doubt that the Leonard Silk will be able to take all 25. But at this note, I think it's a convenient place to draw the curtain. I apologize if I couldn't take your questions. Thank you so much, Leonard Silk. It was indeed a very, very practical session with you. And I apologize for the glitch on our end here while sharing your screen. But overall, as you can see, there's still 25 questions unattended to. And there's an appeal from someone here saying I should please ask the question. But for time constraints, we're unable to take all the questions. And we thank you very much for making this a success today. Leonard Silk, over to you, Sue.
Thank you very, very, very much once again, Leonard Silk. Your presentation is most highly appreciated. The chat box is, it's reached the maximum. That's separate from the questions and answers. We have over 99. 99 is the maximum number of questions that the chat box will reflect, but we have much, much more than 99 people with all kinds of expressing their gratitude and saying thank you very much for your presentation. I join them in thanking you for making out time and for the questions and for answering the questions as well. Thank you so, so much for this. I just wanted to add, if I'm permitted to, there was a question that was asked about because I've always had thoughts about it, and I'm not aware anyone has tried it here in our jurisdiction. And that's where you have a situation where a witness dies. Like you said, when maybe you have old, maybe land or chieftaincy matter, and the witnesses are old, and the trial takes a long time. I know we have provision in our rules for taking depositions, but I'm not aware people take advantage of it. And I know in other jurisdictions, because one or two times I've been involved in multi-jurisdictional cases, especially in the United States. They tend to, before trial, they tend to actually do what they call depositions, which is actually like trial. So that the court appoints a I don't know I can't remember the name now. So someone who is authorized by the court to take evidence, and then the parties go before with their witnesses. They depose their witnesses, you cross-examine, and everything is recorded. And I think, and I understand, I was wondering why they did that, and because they would still go back to trial and do the same thing all over again. And the explanation was that, okay, so a situation could arise where, for instance, for one reason or the other, the witness dies, maybe the case doesn't, or for one reason or the other, the witness is not able to give evidence. Some of our rules actually have provisions for depositions, but I'm not sure we use it the way they use it or the way they use it in the US, like I experienced in the case, in the multi-jurisdictional case. So maybe because that happens quite a lot, where you have a witness dying and then the evidence goes out of the window, and then you have to go and look for another witness who may not be so suitable. Maybe we should try it and see although I'm not sure whether evidence gathered during such depositions, I don't know if it has exactly the same status as evidence gathered, but it allows you to take that evidence, you transmit it to the court, almost like taking, when you write letters of request, you take evidence abroad. But in this case, you're not taking the evidence abroad, you're taking it locally. And the evidence is gathered, is documented, and is transmitted to the court. And the court can look at it. The only difference is that the court will not have the opportunity to view the demeanor of witnesses. So that will be, I'm just suggesting that maybe we should explore those provisions of our rules. I'm not aware of anyone has tested them here, and how one can use them in such circumstances where you anticipate a witness may pass on, or the cross-examination may not be possible before the trial is concluded. That's just a thought. I mean, as I said, it's not something that I'm aware anyone has tested locally here. But I know our rules.
But yes.
Go ahead, let us know.
I'm just wondering, I'm actually wondering with you to say that maybe what we can do, especially as senior lawyers, any opportunity to have a chat, why can't we amend the respective rules to include the positions of all the statements on oath? Maybe. In that case, that means from the get-go, the person who, but of course, the probative value will come because you cannot also cross-examine.
No,
and the demeanor.
The demeanor. I think you can. I think they allow them, at least in other jurisdictions, they allow them to cross-examine. But it's the demeanor. The judge might not be able to evaluate their demeanor.
Yeah.
Okay. So thank you. I just wanted to drop that in. Maybe one of our colleagues will try it out sometime, and then we'll get the court to pronounce on the status of that kind of evidence. Thank you very, very much once again. Okay. Thank you. Okay. So I thank our colleagues for dialing in today again. We had a good attendance. Tomorrow, which is day 6, we have 2 sessions. The first session is being anchored by Mrs. Funke Adekoya, SAN. It's just focusing on, I know the learned silk today touched on peripherally on examination, but tomorrow we're doing a deep dive on examination of witnesses and all the rules and the tricks and the for examination, from examination in chief to cross-examination and re-examination. It promises to be a very interesting session. It's going to be a deep dive into examination of witnesses. And I think we're going to emphasize a lot on cross-examination, which is a very, very, very important skill for a litigator, irrespective of whether you are a criminal litigator or a civil litigator. And I think Mrs. Adekoya is eminently qualified to anchor this session. I'm aware that her slides are ready. I am aware she's also on this call, and I thank her. She's been consistent in dialing in for our sessions. I thank her again for dialing in today, although she's been very quiet. So we're looking forward to Ms. Adekoya's session. And then after Ms. Adekoya, we have the next session, tomorrow, the second session tomorrow is critical analysis of evidence, application of law to evidence, and final addresses. So basically, final addresses, summing up your case, which will entail, of course, reviewing all the evidence adduced during trial, appraising the evidence, ascribing probative value to the evidence, and applying the law. And generally, find is very strong and solid final address. To anchor that, we have Mr. Ugo Ikwabi, who is called to the Nigerian bar, and he's practiced in Canada for almost I think, over 20 years now, and is a King's Counsel in Canada. So that promises to also be a very interesting session. So tomorrow promises to be a very interesting day. So we enjoin our colleagues to dial in as usual, and we're looking forward to the sessions. Thank you very much. Thank you very much, Leonard Silk, once again.
Thank you.
So I wish everyone a pleasant evening, and we look forward to seeing you tomorrow. Thank you very much.
Thank you.